Hello, Attorney Masah SamForay here, owner and founder of the Foray Firm with offices in Chicago and in Houston, and I am here to talk to you about all things immigration. So today's question of the day is, can you explain adjustment of status versus the consular processing? Yes, I can. So adjustment of status is only available to people or aliens who are presently located in the United States. You have to be here in this country in order to adjust your status. Otherwise, you have to go through the consular processing system, or you have to apply at the U.S. consulate or U.S. embassy in your home country. And so here are some hypotheticals. I am a U.S. citizen. My husband lives in Sierra Leone. Shout out. Can I apply and do adjustment of status for him? No, you cannot do an adjustment of status for him because, again, adjustment of status is only available to aliens who are presently themselves located within the United States. So since your husband is still in Sierra Leone, he's going to have to go through the consular processing system. Hypothetical number 2. My husband is a U.S. citizen. I am presently in the United States on an F1 visa. Can he apply and do adjustment of status for me, or do I have to go back home and come back again? No, you do not have to go back home. You can stay right here with your husband in the United States, and he can simultaneously file an I-130 and an I-485. The I-130 is the petition for alien relative, and the I-485 is an application to register a permanent resident or to adjust status. So you can stay right here in the comforts of the United States with your spouse while he simultaneously files those documents for you, as long as you are still here on a valid F1 visa. So due to the long processing times and the high rates of rejections, especially in specific countries where the U.S. government has flagged them as having a high rate of fraud, you might wonder why anyone would ever choose to go through consular processing. The answer is simple. There are some circumstances where you have no choice. And so if you have no choice, you're going to definitely have to go back home and go through the consular process, and you're not going to be eligible to do adjustment of status. And that is even if you are here in the United States. Because, for example, if you are in the United States and your husband or your wife is trying to sponsor you as their spouse, let's say that they are a green card holder and they are not a U.S. citizen and they are trying to adjust your status, you as the spouse that they are trying to sponsor, so you are the seeker spouse, you cannot stay in the United States unless you have a valid visa. So again, under the last example that I gave where that person had an F1 visa, they had a valid pending F1 visa that had not yet expired. And that is why I gave the answer that I gave. If you came here on an F1 visa, on a tourist visa, or any other kind of visa, and your husband is trying to sponsor you on a spousal visa, but your F1 visa or your other visa that you came here lawfully with has expired, you are no longer lawfully within the United States, and therefore you have to leave and you have to go through consular processing, and then you can come back again. So the key is to find out whether or not you can adjust your visa, whether or not you can find some way. If you came here on an F1 visa, can you get an extension? And I went through a number of different options to get up to 2 years worth of extensions after graduation when you came here on an F1 visa. So you're going to want to consult with an immigration attorney who knows the law and knows the way to make sure that you are here lawfully if you want to avoid having to go home and go through the consular processing, as opposed to being able to do an adjustment of status right here in the comforts of the United States.